Today we're interviewing Charles Hensey as a part of the continuing North Carolina Bar Association Wake County Bar Project, which records the history of the profession, particularly in the 10th Judicial District. Today is December 4th, 1997, and Mr. Hensey has graciously agreed to appear here today and discuss his career as a member of the bar. Mr. Hensey, I wonder if you could start us off by telling us when you first thought of the law as a potential profession and your educational background.
Okay. First of all, Tom, thank you so much for giving me the opportunity to appear and be a part of this program. I feel it's a real honor and I'm quite flattered. My roots are in southern North Carolina, in Robeson and Scotland County. Although I was born at Fort Bragg, I guess technically I'm an Army brat, but my life in the Army didn't last too long. I grew up in a small town called Maxton, which is right on the border between Robeson and Scotland counties. Attended the public schools down there. Attended Duke University undergraduate program. Spent 2 years on active duty with the U.S. Navy because I went through the Navy ROTC program at Duke. This was back in the mid-1950s when everybody had military obligation, and I sure didn't particularly want to go in as a private, so I figured being a naval officer was a better deal. While I was in the Navy, I was on board a ship and had the opportunity to participate as a member of the court in a couple of court-martials on board the ship. And that's what spurred my interest in the law. In undergraduate school at Duke, I majored in business administration, and we had taken a business law course, and I thought that was the worst course I had ever taken. And there was no way in the world that I would ever be a lawyer after that course. But seeing it operate, I was fascinated with the process. And I wasn't sure what I wanted to do with my life at the time. I sure didn't want to stay in the Navy. And I didn't really want to go in the corporate world. So I wrote, my story is from the middle of the Atlantic Ocean to Carolina and asked them what I had to do. And the reason I went to Carolina, my joke is that after 4 years at Mr. Duke's University, I was so impoverished that I had to throw myself on the mercy of my state to continue my education. Okay, anyway. And Dean Brandis was the dean at the time. He wrote the nicest letter I think I have ever received from anybody. He didn't know me from Adam's house yet. And said, okay, this is what you've got to do if you're interested in coming to law school. And I did it all. And in due course, I got a nice letter back saying, we'll see you in September. And so I was at Carolina from 1959 to 1962. It's a class of 62. Andy Van Orey, the Chief Deputy Attorney General for the Attorney General staff, is a classmate of mine. Louis Costin, who is a Special Deputy Attorney General, also a classmate of mine. And there are several others. Bob Burris, who used to be a Superior Court judge up in Charlotte, Mecklenburg County, is a classmate of mine. There are others. Okay. The class of 62 has one distinction that I don't know whether we can be proud of it or not, but I'll put it on record. We were the class that that had the disastrous bar exam results. 1962 is when more people flunked the bar exam than passed. My recollection is 81 passed, 80 passed and 81 failed. And the failure had no relationship to class standing or anything else. I think practically all of the clerks for the Supreme Court that year flunked. Okay. And it created a tremendous stir, a tremendous furor. There were flaming editorials in the News and Observer. And the State Bar and the Board of Law Examiners, well, I guess they didn't have a Board of Law Examiners then. They just had the State Bar. Well, you'd only had about 2 people, I think, at the time. Ed Cannon, and maybe Bobby James was there as Cannon's assistant at the time. So there was a tremendous uproar about that. Dean Brandis wrote hot letters to the News Observer and accused the Board of Law Examiners of being back in the 19th century, and it was lots of fun. Back in those days, of course, you only had one bite at the bar exam. They didn't give it twice a year. They only gave it once a year. So there were a lot of folks who had to wait a full year before they could take the test again. And of course, the Supreme Court was just in an absolute state of panic because their rules back then were that all of their clerks had to be licensed members of the bar. So they immediately, of course, conferenced and did away with that rule. Okay. So anyway, after finishing law school, and I passed, by the way, that year, and so I hold this over a lot of my classmates who are much more successful than I am, but I can always come in and say, well, I passed the bar that year and you didn't. Okay. I went to work with a small law firm in Lumberton, North Carolina. Lumberton's near my home. The name of the firm was Johnson, Biggs, and Britt. It was a general practice firm. And in that law firm, I did a little bit of everything, I guess. You name it. They had a couple of merchants who were on a retainer basis. And of course, I had to do all the collections work, all the foreclosures, all the claim and delivery, this sort of thing. And back in those days, this was before the development of due process. And so there wasn't a hell of a lot of due process back in those days. You did notify the people, but you just sort of halfway did it. And then you went out and got their tractor or whatever it was that you were repossessing. I even got a man's mule one time and hauled it in. So it was and of course you were on the indigent list. So I did a couple of criminal defense cases, and the senior partner got sick a couple of times, and he had a big real estate practice. So I spent a lot of time over in the Register of Deeds office doing real estate work. It was an interesting experience. In retrospect, it was very, very helpful because it gave me a good look at the way the courthouse works at the local level and how law practice works on a local level. But I wasn't too happy there, for lots of reasons that are really not relevant now. I began to look around for other employment, and I learned that the Attorney General's office in the Highway Division had a lot of openings, and several of my classmates had gone to the Attorney General's office. I think Andy Van Orey was there at the time. He wasn't in Highway. I think he was over in Education. But Bowie Costin was over in Highway. Tom Wood, who was, I guess, a year ahead of me, maybe. I can't remember. He was at Highway. There were 2 or 3 others. The reason that Highway had so many openings was that the interstate program had begun to increase, and the amount of federal money coming into the state of North Carolina had greatly increased. And the North Carolina law had been changed in 1960. Before 1960, in North Carolina, the condemning authority didn't have to file any papers. Just all of a sudden you might wake up one morning and the bulldozers were out in your front yard. And that might have been the first notice you had of anything that was going on. And the property owner had the burden of bringing a lawsuit if he or she was interested in recovering compensation from the highway department. And these cases would drag on for years sometime. One of the favorite ploys of the highway lawyers back in those days was to immediately deny title and put the landowner to the burden of proving title. And this was back before the marketable title statutes. when you had to prove title under a couple of old cases, Mobley v. Griffin was one of them. You had to establish a connected chain of title either back to the sovereign or back to a common source. It can be done, but it's expensive to do that sort of thing. Okay, and so when a property owner was faced with the possibility of having to prove their title, most of the time they gave up and took whatever it was the highway wanted. But anyway, there was a Supreme Court decision that said title to the property did not vest with the Highway Commission until all of this long, time-consuming litigation process was over. So it might be years from the date the project was started until the highway actually acquired title. The federal government required that the Highway Department and the state of North Carolina be able to certify at the beginning of a project that they owned all of the land that was required and needed for the project. So North Carolina law had to be changed, and it was changed in 1960 to put the burden on the Highway Department to bring a lawsuit. And what was adopted was a process that had been used by the federal government and by a number of other states over the years, what is known in the trade as quick take. That's Quick-Take, where the Highway Department deposits with the clerk of court at the time it files its lawsuit its estimate of just compensation. And at that time, it can actually take the land. Title will transfer and vest in the Highway Department. And then the litigation is about how much money to pay. Okay. Well, obviously, with the Highway Department having to file lawsuits, this just increased the number of lawyers that were required, by 3 or 4 or 5 times as much. So there were openings over at DOT. And blessedly, after an interview process, I was hired and came to work May the 12th, the day after Confederate Memorial Day. Confederate Memorial Day back in those days was May 11th, and that was a state holiday. This was 1965. So May the 12th, 1965, I came to work on the Attorney General's staff.
Who was Attorney General at that time?
Thomas Wade Bruton, affectionately known as Colonel Bruton. And there are lots of stories about Colonel Bruton. He was a good man. At one time, he had been a very brilliant lawyer. He had served in the legislature a few terms and everything. But by 1965, Colonel Bruton was in his declining years. And it was quite a shock the first morning I came to work to find out how things worked back in those days. I thought I would come in and sit down in my little cubby hole over in the highway building, and somebody would put papers on my desk and I would do my thing. That wasn't the case. First thing we did, we all assembled over in what was called the main office back in those days, on the second floor of the Justice Building in a conference room. And the senior lawyers sat around the big table that I guess the Attorney General still has. They had it the last time I was in there 3 or 4 years ago. And the Attorney General sat up at the head of the table, and his chief deputy sat on his right-hand side. And they took the mail, and all the rest of us peons sat around against the wall. Okay, all right. And they could put the whole Attorney General staff in one room. Gives you some idea of the size of the office. The Highway Division at that time had more lawyers than the rest of the Attorney General's office put together. But what we would do at this morning conference was the chief deputy, Mr. McGalliard, Harry McGalliard, would read the mail. The mail would be put in front of him, and he'd read these letters and decide who had to get them. Was it a utilities problem, or was it a highway problem, or was it an insurance problem, or whatever it was. And so Mr. McGalliard would read the mail. Sometimes he would make rather caustic comments about some of the letters, especially those written by people who didn't really know exactly who to write to. And so the mail would be distributed. And then we would adjourn from then. Occasionally there would be other announcements. Then we would adjourn from that evolution and go over to the highway building. and assemble in the highway conference room, and there would be a second reading of the mail, and this would be of the highway mail, and it would be passed out to the members of the staff. And then after this, we all broke and went downtown for coffee. Then we came back and did a little bit of work, and then we broke for lunch and came back and worked a fair amount in the afternoon. It was a relaxed time back in those days.
Before you go on, I wanted to just ask you, you started the day after the Confederate War Memorial Holiday.
Yes.
I hadn't heard about that holiday. Could you just tell me about how that was celebrated in those days?
Well, Confederate Memorial Day was different from National Memorial Day, okay? Because we were a lot closer to 1865 than we are today. And so the memories of the Civil War and everything were still strong in a lot of people. So I don't know when Confederate Memorial Day became a holiday. I have no idea. I'm sure that you could research it in the session laws and find out. But it was May the 11th was Confederate Memorial Day, and that was a state holiday. Okay. The state did not celebrate National Memorial Day. It celebrated only Confederate Memorial Day.
What was the rationale given for that?
Well, because North Carolina had lost more troops in the Civil War than any other state. You know, North Carolina was the last to secede. There was tremendous Union sentiment in the state. But once North Carolina seceded, it sent more troops and lost more people than any other state in the Confederacy. So there was a lot of strong feeling about the Civil War and about the sacrifices that North Carolina had made during the war. You know, of course, that Wilmington, North Carolina was the last port to fall. And the railroad that ran from Wilmington to Weldon, the Wilmington to Weldon Railroad, was known as the lifeline of the Confederacy.
As a long-term state employee, one who observed policy change, do you recall when the state stopped observing this holiday and what the reasons
Probably
were given?
sometime in the mid to late 70s, but I have no earthly idea. As the state, you see, it's hard to understand for somebody like yourself who has not been raised in the South. But even as late as the 1960s, the South was still isolated from the rest of the nation, and the economic effects of the Civil War were still prevalent in North Carolina. And there's some of this today if you go out in the more rural sections of the state and talk to folks. You'll still get little echoes of this. See, the Research Triangle Park in Raleigh really is entirely different from the way the state of North Carolina used to be 35 years ago.
And what was it like for you coming from a small firm in Lumberton and starting to work in the Attorney General office in Raleigh? What was it like in those days to practice law in Raleigh for you?
Well, of course, I didn't really practice law in Raleigh, you see. I was on the staff the first year. Well, first of all, I was so glad to get out of Lumberton that anything would have looked good. It was just like heaven, like I had died and gone to heaven, no question about it. The highway division was very well organized at that time. It was highly structured. The tasks were differentiated. For example, they had two lawyers, one of which was Fred Parker, as a matter of fact, who did nothing but consent judgments. That's all they did. Now, I know. Can you imagine that? My job was to prepare the pleadings for the condemnation cases. Okay. You say, well, hell, there's nothing to preparing pleadings. Well, huge stacks of paper would come in. They were called parcels, and the reason was that each one of them pertained to a particular parcel of land. Now, the pleadings were basically boilerplate. They were pre-printed, but they referred to Exhibit A and Exhibit B and Exhibit C, and these are the ones that the lawyers had to prepare. And you had to for example, there was a title certificate attached on these pile of papers. So you had to go through and study the title certificate to figure out who to name as parties defendant, who owned the land, okay? You had to figure out, of course, what the encumbrances were against the property. You know, sometimes they would show up in the title certificates, and sometimes they wouldn't, okay? Title lawyers got their work through political patronage. It was a pure patronage system back in those days. And it was through the governor's office. It was not through the attorney general. And so the governor would send over a list of lawyers in each county who were to do the title work. Now, this list bore no relationship to the lawyer's ability as a title lawyer. It bore a lot of relationship to how much money and how hard he had worked for the governor in the last political campaign. Okay. So some counties, you had really top-notch title people. In other counties, you had folks who hadn't been close to the register of deeds vaults in 20 years. Okay. And so it was a real problem just a lot of times to go through these damn title certificates and figure out what the true status of the title was. The people who acquired the parcel, who acquired the land, the right-of-way agents, they were called, the negotiators, were required to keep a diary. Every time they talked to somebody, they had to make notes. And a lot of times you could go through the right-of-way agents' diaries and find out all sorts of information about the title. A lot more about there sometimes than you could from the title lawyers' things.
Good question. You kind of set the stage for this being a major change in the transportation system in North Carolina. Which major interstate highways were about to be built, hadn't been built at the time you came on?
Okay. Well, the Interstate Highway Act, the National Defense Transportation Act, or whatever it was called, was put through by the Eisenhower administration. And the justification for the interstate program was that this would be a system of roads where you could move military equipment all over the country. Okay. That was the original justification. And I guess this act was passed sometime in the mid to late 1950s. Okay. The funding, though, really did not start up until 1960 plus, about when the highway staff increased so much. Okay. North Carolina had moved toward some type of improved highway system. Okay. One sort of highway that had been considered was, for example, if you've ever ridden between Chapel Hill and Durham. That's a divided highway, but it has service roads on either side, and there are crossovers periodically from on-grade crossovers. Okay. A lot of highway engineers thought this was going to be the highway of the future, and there were quite a few of those that were built, the Chapel Hill-Durham road being one. Okay. Clearly, the decision was made at some point in time to go to the freeway system, or the Autobahn system, or whatever you want to call it, with the current interstate system, where there is severe restrictions on access, and you could only get on at designated interchanges and this sort of thing. The right-of-way is fenced, and all of this good stuff. Okay. A lot of North Carolina had started several projects. Interstate 85 around Hillsborough is a good example. Hillsborough and Durham. And Interstate 95 between Lumberton and Fayetteville was another one. And I think there were a couple up in the western part of the state that had started off with the old design, and then they switched over to the new design.
Okay, as you were litigating all over
Mhm.
the state, I imagine you have some favorite stories about matters that went to trial, perhaps particular judges,
Well,
other attorneys. Would you care to share
yeah.
one of those?
Okay, well,
Start with one.
yeah, well, of course first of all, you had to do the trial work in the county where the land was located. So you weren't on your ground, you were on the landowner's ground. Highway cases that went to trial basically fell into three categories. Okay. Category one was where the highway folks just absolutely blew it. Okay. Where their estimates were just wrong. Okay. Category number two was where you had an excessively greedy landowner and there just wasn't enough money in the treasury of any governmental entity to satisfy that individual. And category number three was the one where nobody knew. I mean, those were the true difficult ones. Okay. You get 100 appraisers and you get 100 different opinions. Okay. Unfortunately, it seemed like most of the ones that we wound up trying were in the first category, that is, where the highway folks didn't do it right. That's not true, of course, but it seemed that way. Okay. In any land valuation problem, as you well know, there is a difference of opinion. There are broad limits as to value, but beyond that, who knows? Only God, I guess, knows. Okay. And so many times there were legitimate differences of opinion. Well, if you were in the home county, of course, the home folks tended to look after the home folks. And you had judges who generally were in a judicial division, and they knew that they were periodically going to have to come back to that county, and they were going to have to stand for election periodically. So where did the judges fall? Okay. They didn't necessarily fall on the side of the highway all the time. They tended to fall on the side of the property owner. And I don't think this was all bad. This is not to be critical of judges. I think if I were a judge, all things being equal, if you had a landowner who had been forced to sell their land, and many, many times the land would be chopped up into little pieces. The cases we hated the worst were the so-called farm splitting cases, where a fellow had, let's say, 200 acres or 250 acres of farmland beforehand all together, a nice compact unit where his tractor could just go down his rows and everything. And after the highway came through, you had this big interstate highway right slammed through the middle of it. And you had all the barns and the houses on one side of the interstate and all the fields over here on the other side. You had to go 2 or 3 miles down the road to get to a crossover or an interchange. Okay, those are tough cases. They're hard to appraise, first of all, because nobody really knows the effect. Okay, and so there tends to be a lot of sympathy for landowners in that situation. So the judges, I'd say the great majority of the judges tried to be fair. They really did try to be fair. I think generally speaking, they tended to fall on the side of the property owner, which I think I would have too if it was a questionable ruling where you weren't really sure what the law was and this sort of thing.
Do you recall a particular trial, or I have other questions too, one isn't coming to mind right now,
Yeah.
a particular trial or hearing that you've enjoyed?
Well, there were lots of them, of course. One problem you had was deciding on what land had been taken. The highway was required to go out and survey the property and then prepare a map and show what was taken and this sort of thing. Well, there were lots of times there were squabbles over the map. And the map was one of and these issues all had to be heard by a judge. The only thing a jury heard was the amount of damages. And by the time it got to the jury stage, everyone had agreed on on how much land was there before the highway came through, how much land the highway took, what the access restrictions, if any, were, and this sort of thing. Okay. But all these preliminary issues had to be heard and resolved by judges. So there'd be hearings on the map. Sometimes there would be some question about the parties, of ownership of land. There was sometimes questions about whether parcels of land could be joined together for purposes of the lawsuit. For example, let's say A and B owned a tract of land by tenants by the entireties. And A and B owned the